really wouldn't be the same if I didn't give this final synopsis of what's been going on with this. Very important with the judicial and clerical, legal and lawful notice, do not use it early. What you want to do is wait until the judge gives you some fake orders. You can tell them because they will sign it judge, magistrate judge, district court judge, versus presiding judge of the 2nd District Court for the County of Clark in the state of Nevada. Really naming the courthouse. None of this bullshit, district court judge. That's fraud. They're acting administratively and waging war against the Constitution. And every judge in America right now, the 19th of January 2025, every judge in America is guilty of treason. Supreme Court justices all the way down to that guy in traffic court. Because they're all taught and trained how to do administrative processes and not correct legal and lawful ones. But let's go over this in a little bit more detail, beginning with the front of it. One, the paperwork has to be entered into the court record, and then there's a lot of confusion about, is it public or is it private? Well, we know they're de facto, which means they are for-profit corporations, which means they're private. When they share it, your arrest record, for example, with other agencies, those agencies, the apartments, jobs that are coming to them and going, is this a good person? Can we trust them? Are they criminal? Those people are not public either. They are private. Title 28, Section 3002, subsection 15A is the United States is a federal corporation. B are subdivisions and departments. And C are instrumentalities. B might be, for example, the Monterey Park Police Department, the Monterey Park Fire Department. A, U.S. Postal Service, city, county, state, postal service. They're all departments of the corporation to help keep the corporation going. So we want to go and make sure we're not part of that. And even if you're on duty and you're all sworn in and you have an oath of office, you're still not part of it if you did the action after work, or if they try and take your children, or if they're trying to force you to pay taxes from your job. One of the things we want to do is make sure we don't get stuck with attorneys, because they will fuck up your whole case. So really make certain, if you have to, go see my video, which I'm going to be doing. It'll be up before the end of the month, about phoretic canvas. Because I'm tired of these judges forcing attorneys on us when we know they're bastards. We know that defense attorneys work to defend the public from you. Office of the Public Defender. Think about that. This is the public. This is you. This is your attorney. He is there to defend the public to protect the public from you. Think about the words you use. They're real important in law, and they're dirty bastards. So we say here in 2 that we put all people and persons. That's saying that when you go to sue them, are they in their individual capacity, people, or are they in their corporate capacity, persons? And then, of course, it mentions corpus juris secundum, and this is the only thing I've ever seen that quotes it properly. Everybody's using that old 2010 or something quote about section 4, and it's wrong. You want to make sure also, go back and double check that it says, I do not consent in point 2. Well, if you're suing somebody and you want to put the judge on notice, then you do consent to these proceedings. I want to win $10 million. So get rid of that. A lot of this paperwork you have to go and clean and make sure it's all yours. In point 4, you have to go through the individual things. And again, I think I mentioned this in the actual lecture 1, but again, be very certain, because impeachment, sometimes the state constitutions do it under legislative, executive, and judicial, and they give different grounds and different methods of impeachment. And then in the paperwork, you will put all 3 of those, unless it's something very specific, because they are clerks, which is kind of legislative. I know, it's quasi, I'm not going to argue with about it, but the judicial section will definitely have the judges, what it needs to impeach them. And that's what you need for that point. And quote it, section, article. Point 6 talks about if at any time in the past I inadvertently waived my rights, and we come into that again full circle much later. But in the later ones, it's like neither one of them really shows the source. You can look up Marion et al. Versus Jicarilla Apache Indian tribe. And it's a case where it was decided that because the Indian tribe didn't reserve its rights through contract, doesn't mean that it forever waived them. And there's lots of case law dealing with jurisdictional issues where, again, it says that you can always challenge jurisdiction. It's never waived. It's never forgotten. You can always bring it up from the dead, even after conviction. Now, in point 7, you can get a little more specific and you can change things around, but really you're bound to inform your colleagues, your superiors, and subordinates. Well, who is that? The lawyer, you're giving it to the prosecutor, you're giving it to the CPS agent, you're giving it to the lawyer for taxes. He must inform his colleagues, the judge, the clerk, law enforcement. All members of the law society are his colleagues. It's pretty clear. And then if he's got superiors, if he's an assistant district attorney or assistant state attorney, he has to inform the boss. Might come back and save your ass. And then another thing that's real important in here is 9, Platsky versus CIA. In that case, the judge can't dismiss your case because you're a pro se litigant. Now, there's a lot of controversy with, there's a Supreme Court case, Haynes versus Kerner, that says pro se litigants are not held to the same standard as attorneys. There's another case, I don't have it on hand, I'll pull it up and quote it. But in that case, it was previous to Haynes, and it said that by giving pro se litigants unlimited refiling, it gave them an unfair advantage. And so it was decided that the pro se litigant is still held to the same procedural standards as attorneys, which means if you're going to file a motion, you must have a notice of motion, when, where it's going to be heard, and an affidavit in support of motion. Always 3 documents. You can combine the affidavit with the motion. You still need the notice of motion. So be real careful with those things when you're filing paperwork. Make sure you do things right. Lots of these acts, I really don't think you're going to have time to read all of them. The Maternity Act, the Shepherd-Towner Maternity Act, Parents Patriae, all kinds of shit in there. Lots of stuff, but, read what you can. It's really important, if you're going to hang your case on something, to read that case. If you're going to be talking to the judge about how Chevron was overruled and now you must use Loper, read Loper. That Haynes case, Haynes versus Kerner, is 404 U.S. 519, and they had Veigel, Veigel, versus Texas Boll Weevil Eradication Foundation, 549 Southwest 3rd, 193. So that's where it said that you are held to the same procedural standards. Make sure you put things in that, if it says something about, I'm here on behalf of my California corporation. I was born in California. Where were you born? Doesn't matter how many states you live in, where you live now. The birth certificate, if you're referring to things like that, is the state of your birth. And if you read any of those things, Parents Patriae is probably the first one of those I would read. But this is going with the things, and it says in point 20, I've recorded my paperwork in the county recorder and the notary public. This document, you don't need to do that. With other things, you might. But you don't necessarily have to change it. You can just tell the judge, well, I tried to record it there and they wouldn't take it. Okay. Even when you say things under oath, and this, I swear it's true, you can look everywhere. They must tell you that you lied and allow you to go and correct it. Oh, did I say that? I meant to take that out. No, you can strike that line, Judge. I never recorded it. It's not that serious. All kinds of people tell you all kinds of things, and they just haven't had the experience I've had. There is this secret absolute oath, and the public oath is referring to the notarized oath of office. The secret oath is what they make behind closed doors in the room 322. Look up that. And you know, most of this then, it becomes really simple. It's straightforward. You might have to look up a lot of legal words. If you come across a word you've never heard before, go look it up in a legal dictionary. Ooh! Oh, I moved mine. My legal dictionary is usually at hand. It's across the room. But this is really just to hold judges to do the right thing and to be in a court of common law. The last things it says is void where prohibited by law. And that's something that I put in all my paperwork. So if you don't know me, you don't trust me, and the judge looks at the document and goes, "Are you fucking kidding me? I should arrest you for this." What's illegal? It says void where prohibited by law. And then Platsky comes into play again, and he must allow you to edit it. So it's very safe to use. I recommend you don't use this in the beginning. And please, for God's sake, stop fucking sending anything to the judges in the beginning. All kinds of crazy fucking idiots are, "Oh, Judge, do you have your oath of office? And do you have a bond? And I need to see you." Shut up. That's fucking David Straight shit. And his wife went to jail for 8 months. That shit doesn't hold water with them. This shit does. When we filed this recently, this year, they kicked a judge off the bench, and we are waiting for a new judge to come in. It says UAM. Can I make that up? Not unless I knew what the fuck that means. Unassigned magistrate. That means this thing kicked a federal judge off the bench because he didn't even want to hear this shit. So it is strong, it is powerful, it's crafted. Make sure that before you use this, you have the affidavit 1D testimony, because that in points 17 to 26 has a lot of shit about Loper Enterprises and congressional acts and stuff that you need to really enforce this. So you have to build. This is not the first thing you do. If you have my Patriot package, it says on there, do not use early. You want to make sure you have 3 fraudulent orders from the judge, or 3 times where he's violated canons of law, practicing law from the bench, showing prejudice, showing incompetence. And then, and only then, do you use this. Hope that helps. Godspeed to everybody. We're going to turn this world around. 1 court, 1 judge, 1 cop, 1 lawyer in prison at a time, if that's what it takes.